Good afternoon. It's Tuesday, February 14th. This is a school board workshop, and the time is 12 p.m. Today on the agenda, we have a review of Neola policies 8,000, operations, policies 9,000, community relations, the second review of Neola bylaws, and the review of the February 22nd, 2023 regular agenda and good of order. We'll begin with the review of the Neola policies. The school board is in the process of converting and adopting Neola policies. This will help streamline and ensure consistency and guarantee that we are legally compliant. We'll be going through our policies by subject area, chunks at a time. The board has an opportunity to review the policies ahead of time and individually. We have had a chance to comment on them and ask questions. These policies are being pre-briefed through these workshops. Once they are reviewed, we will go to the first reading and second readings. Thank you, Neola, for joining us today. Also, thanks to the staff for all your hard work on this critical project. Attorney DePay Bruno, will you please introduce the Neola team?
Thank you very much, Mr. Chairman. With us today is Tom Young as well as Francis St. James, and they will be walking us through board policies 8,000, 9,000, and then another review of your bylaws. We're going to begin today with the 8,000s, which is operations.
Mr. Chairman, board members, new board members, welcome. Existing board members, good to see you again. It is our practice, unless you decide to change our practice, to ask you whether you have questions concerning any policies in the 8,000 series. Rather than go through line by line, policy by policy, you, as the chair has indicated, you've had a chance to review them. I understand that you've asked questions, provided input. So my role here would be to be responsive to any questions you might have. And with that having been said, Mr. Chairman, I turn it over to you, and I'll be responsive to any questions that are raised.
Board members, on the 8,000 operations, do you have any questions for Neola?
Nobody else?
Nope. Do you have?
Oh, all right. And some of these are very small, Tom. I apologize, but I'm trying to make some of this stuff a little bit more user-friendly. 8315 is titled Information Management. It's really not about information management. It's about litigation holds. And I'm just asking that you change the title to litigation holds so that when people are looking for a particular topic, it's easier to identify.
I'm comfortable with that. It's a good suggestion.
Thank you.
Okay. Yeah.
Any objections to that, or Attorney DePay?
So, Mrs. Morgan, if we could wait, because what they are going to do is as the topics come up, questions or corrections need to be made, Ms. St. James is going to do it in real time for us.
Oh.
So she's in the process right now of changing that title.
Oh, okay.
Okay.
Okay, policy 8350, I have two questions. And because there are no line numbers, it's really hard to tell
Yes.
you. But the sentence reads, the district shall record the student's permanent record and shall indicate in that record if the number recorded is not a social security number. I read that and I said, huh? And I don't know whether that comes from statute or, and it should be about halfway down.
Under the heading of
I didn't do that in my notes.
It's 8350 confidentiality. And-
Find the second question.
Could you repeat that, please? Could you repeat that, please?
Sure. This district shall record the student's permanent record and shall indicate in that record if the number recorded is not a social security number.
Yes.
It's going to be under limited use of social security numbers, I believe. It's in that section, it's 1, 2, 3, fourth paragraph pursuant to state law. And just to elaborate a little bit more on Mrs. Morgan's question, the issue is that you may have students who do not have a social security number, and whether or not this is what this particular paragraph is addressing.
Yes. That is what it is addressing.
And is that a legal requirement? That's something that we must have, or?
That is a requirement. I don't believe it's new. If there is wording which, I don't think that we've changed the wording. I think that wording is consistent with the statute that is applicable here. But if there is wording that you would prefer that would make it more clear, I'm certainly open to suggestions.
Well, I didn't prepare any alternative wording, so I just didn't understand what it was. And then Attorney Dupuy Bruno told me what it meant when we had our conversation, but I didn't go back and rewrite it. And we can let it stand. It depends on the board. I'm just trying to make some of these things.
I think for this one, Mrs. Morgan, has all the board seen the language now that she's referring to? So what this particular, and Tom, correct me if I'm wrong, but what this particular language is, if a student does not want to provide a social security number, does not have a social security number, another number will be used, and that's the number that will be used on their permanent record.
Right. There needs to be some way to identify the student on their permanent record, and the number, either Social Security or the number which they choose, gives us access to that file.
Okay, my comment would be that if the board understands the sentence, we can just let it stand. I mean, now that it's been explained, there's no need. Now, just a little bit further down, under limitations on collections and retentions of certain information, there's a paragraph that says, and notwithstanding the provisions of this paragraph, if the district used a palm scanner for identifying students for breakfast and lunch programs on March 1st, 2014, it may continue to use the palm scanner system through the 2014-15 school year.
We can delete that.
Okay.
Yeah.
So Frankie, can you delete that?
She's on it now. Thank you. That's a good catch. It's language out of the statute, but it is no longer relevant.
And I should mention to the board that I went through and worked with Attorney Dupuy Bruno on a number of grammatical and punctuational errors before this meeting, so I'm not going there.
And I would, if I might, a comment on that. We received an extensive list of grammatical errors and punctuation, and as I explained to your attorney, many of those, not all, I suspect, and we're in the process of checking all of those suggested changes and errors. Many of those come directly from the statute. We track the language of the statute verbatim. I am not going to represent to you for a moment that the scriveners of the statutes understood what correct grammar was, nor am I going to warrant to you that they use correct punctuation. But I will tell you, we don't change, especially their punctuation, because as all of you know, I suspect, the placement of a comma can change the meaning of a clause or a sentence. So where we have taken language from the statute, we have not attempted to correct it. There is one question that was raised about the use of pronouns, substituting them or they or theirs. That is out of the statute as I understand it, and it is an attempt by the legislature to make statutes gender neutral. I think, and we are attempting to do this, where those pronouns are grammatically incorrect, where they become plural, where the reference was singular prior, we are attempting to change those by using gender neutral phrases such as the individual, the student, the parents, whatever it is, to make them gender neutral and not be grammatically imperfect. But many of these, I won't go into any more detail except to say I find much of the language of the statutes occasionally incomprehensible and often poorly written.
Okay. 8651. I think there's a duplication, and when I was talking with Attorney Dupuy Bruno and Shana Zupke, they think there's a checkoff. But anyway, it starts, upon the recommendation of the superintendent and board approval, a board-owned vehicle may be assigned to an employee if, in the judgment of the superintendent, specific work circumstances require it. And then the next sentence says, an employee may be assigned a vehicle if, in the judgment of the superintendent, specific work circumstances require it. There was some question when we were talking about this yesterday about whether this was actually a three-option thing and you pick your option for, but I don't know why it's duplicated or if it's supposed to be worded slightly differently. Okay.
So Tom, the recommendation that we had was to strike out that second sentence.
Oh, okay. And then that's it for me for the for the 8,000s. I will also say that I came across some things that I think we're not doing as a board, but since this is a policy review, I'll bring anything that I think I found in policy that we're not doing back to the board at a different time. So thank you for the opportunity to ask questions.
Mr. Chairman, to Ms. Morgan's comment about grammatical changes and errors, punctuation, I think I encourage the board to bring those to our attention. I think the most effective way to do that would be notes rather than take the board's time to talk about what is grammatically correct and what is not. And we will take that under advisement and attempt to satisfy your concerns and make them grammatically correct unless it changes the meaning of the statute as it was interpreted or applied.
Thank you.
Thank you.
Okay. Ms. Patrica.
Well, Mrs. Morgan, you got
sorry.
two more. 8510, there was a question about the wellness committee.
Oh, well, that's one that I think, that's the one that I was going to bring to the board.
Okay.
Because I think that's something we're not doing.
Okay.
So, I don't know how to,
And I will mention to the board that every time we do this with a board, there are occasional surprises. The statute requires us to do this.
well, then I'll go ahead,
Fine.
Yeah,
and raise
why
the
don't you?
question. Okay, so this is 8510, and it's about the wellness committee. And it starts out, the wellness committee shall be an ad hoc committee of the board with members recruited and appointed annually. Before the end of each school year, the committee shall submit a report to the superintendent. They describe the environment in each of the district schools, the implementation of the wellness policy, etc., identify revisions to policy. Now, my question is, do we do this? I know that Mary Fisher represented us, but this policy, honestly, thank you. This policy specifies something that we haven't been doing, and I didn't know if it was in statute or if this is something that we wrote in our own policy. Can you,
This would not have come from your policy unless you have substituted a large portion of your policy, and I don't believe you have.
okay, then the question would be, is this from statute?
I don't believe it's from statute, I believe it's federal regulation.
Ah, all right. I'm sorry, I can't give you more help about where it is. It starts out, "The Wellness Committee shall be an ad hoc committee of the board with members recruited and appointed annually."
The number in this one again is
8510.
8510. I will check to make sure. The question is whether or not, regarding the Wellness Committee, is annual appointment.
There's an appointment requirement, a reporting requirement, yeah.
Okay? Reporting annually.
And Attorney Dupree Bruno, what was the other one that?
The other one was 8600.04. We just wanted to know who the commissioner was.
Oh, yeah, 8600.04. The district shall issue a certificate of training to each operator who successfully completes the 40 hours of pre-service training provided by the commissioner. Who is the commissioner?
I must admit, I do not know. That question has not been raised in my presence before, and I will find out.
Okay, then I'm done. Thank you.
Thank you for your insight.
Thank you. So, 8100, the last paragraph, if I may, through the chair, asks the superintendent, and I don't need this answer right now, but how would this paragraph impact Fort Myers Beach in the event the board decides, whatever happens in the end, if they have to become a charter at some point in the future, how does that paragraph impact Fort Myers Beach?
She's looking at 8100 interlocal agreements.
And I don't need that answer right now. I'd just like you to take that question, put some brain matter to it, give it to staff, and then get back to the board if you could, please. Thank you. 8300, this is stuff for the board, Ms. Morgan, as you mentioned, but maybe I'll bring this up during good of the order. The last paragraph of 8300 to me begs the question of the release of confidential information to board members in electronic format. Mr. Chair, may I bring that up during good of the order at the end of the meeting?
Yes.
Excellent, thank you. 8305, second paragraph. I'm not sure what controlled means in that context because the word controlled is not used elsewhere to describe what's happening in that paragraph.
I had the same question, but I didn't ask it.
Where is the word control? I'm sorry.
I'm sorry, I'm trying to pull up the policy. Excuse me. So it's that single sentence below D, data or information will be considered controlled until identified otherwise. What does controlled mean? Is data or information going up above the list of A through D? Should that say data or information collected by the district shall be considered controlled and classified as the following? Like what does, I just don't know what controlled means.
The number on this one again is 8300?
8305.
305.
Would protection, maybe, protected, maybe be better word there.
The question is whether it's in statute.
I suspect this is not statutory.
Yeah, there's no statute attached to this.
I think it is, this is probably one that was arrived at through a meeting of a number of the state school district IT directors. We had a meeting with a half a dozen of the IT directors from different school districts around the state and they are the ones who developed these policies dealing with information technology. And I will check to see what their intent was with regard to information controlled. And I'll get back to the school board attorney on that.
Thank you.
Ms. Jordan?
Does it, underneath of that, though, it does state the reasoning, like, about protecting the district information resources. So is that not, is it that the heading for that?
That's the purpose.
Right.
But I'm not sure whether control is the right word for that. Maybe there would be a better descriptive word or phrase, and we'll check and see if that's an appropriate change, and if it is, we'll recommend it through the attorney to the board.
Okay, also on 8305, if I may, Mr.
Yes.
Chair. Also in 8305, the fourth paragraph. I think it's the fourth paragraph, I don't know, without line numbers it's hard. I think it's the one beginning individuals who are granted access to data. My question was, what happens if they don't do what they're supposed to do? And then that was answered by the next couple sentences. But my question for the board is, should the may be a shall? So, without a line number, I have to read the whole paragraph. Hold on, please. Failure to adhere to this policy and its related administrative guidelines may put data information, that's not it. Okay, it's the second sentence of the second to the last paragraph of the policy on page 2. Employees who violate this policy and/or the administrative procedures promulgated consistent with this policy may have disciplinary consequences imposed up to and including blah, blah, blah. Should it be shall have disciplinary consequences imposed? Predating you, Dr. Bernier, I often discuss the possibility of including sort of falling for a phishing scam and putting the district's information technology at risk as being part of an employee's evaluation. And I'm not sure we want to be granting discretion when our technology security is not being followed closely, and may implies discretion, whereas shall requires action by the superintendent or the supervising staff of the employee. Am I making sense?
Yeah.
Mr. Chair?
Yes.
Certainly the board's discretion, but I would just proffer that every policy has an accompanying procedure, and it possibly where the procedures may have to speak more towards some of the due process rights of employees. So may, the word may, being very specific, the word may be the better word in this case to leave staff with some flexibility as we develop the procedure. But if the board's will is it's a shall, then we would have to move forward, but it could have to be something we could potentially have to work out with our labor unions. Shalls tend to get us into potentially unfair labor practices and other things. Not saying this would result in that, just want to make sure that both sides of the item are being reviewed.
I'm comfortable with leaving it at may, as long as there is some attention paid to the importance of making sure that employees' evaluation somehow includes failure to follow, IT safety measures.
Thank you. I agree with that also. Good.
Okay, thank you. Last paragraph. Superintendent shall conduct an annual assessment of risk, blah, blah, blah. Are we currently doing this, Superintendent? Again, through the chair, you don't have to answer that right now, but if you could provide the board with an answer as to whether this is something we're already doing, I would appreciate it. May I continue?
Yes.
8310. The third paragraph, let me pull it up and make sure that we're on the same page. Personally identifiable. So I don't think I've really understood this in practice, but let me read what I wrote. This exemption applies to all personally identifiable information held by the district. What does this mean, is my question. Addresses and dates of birth of employees, salary of employees. I'm not sure what the last sentence applies to. This exemption applies to all personally identifiable information held by the district. And then it gives, the example of a dependent child, and it gives the example of group insurance information, and then it says it applies to all personally identifiable information, but I didn't think that was true. I thought that unless an employee was an exempt employee, their address and their date of birth and all of that was available to the public through a public records request. And maybe I'm just not understanding it all at all. I don't know, but that sentence didn't make sense to me in the context of what I know up to this point.
I'm still not sure I see where that sentence is, Ms. Patrica.
So I am under exemptions for public records, that second full paragraph. It's
Yes.
short, it's 2 sentences,
I
beginning
see.
personally identifiable information.
Okay.
And it talks about an exemption.
This paragraph is limited to those who are insured by a group insurance plan provided by the district, is the way I would read that.
Okay, so this insurance exemption applies to all personally identifiable information? Is that how I should read that?
Personally identifiable information of a dependent child or of a current or former officer or employee who is insured by a group insurance. So it's just those individuals who are insured.
Okay.
It is that information which is exempt.
Okay, all right, that makes sense to me now, thank you.
Yes, Ms. Jordan.
Does it make sense? Because now I'm confused, because I thought that only if you had to fill out that form to be exempt in order to be exempt. Is that through the chair? Is that correct, Ms. Dupree Bruno? There's that form that you fill out for your exempt status?
So my understanding that this is speaking about a very specific exemption with regards to group insurance plans. So this is not the normal, if you've been a firefighter, if you've been a judge, if you've been a guardian ad litem or public defender, that you have an exemption. I think, am I correct, Tom?
Yes.
So that's different. That's not going to be in the form that you fill out if you want to have the other exemption. Those are very specific to past employment.
So who would be, I guess my question then is, what group insurance plan does this entail? So I think most of everyone in the district belongs to a insurance plan, but they're not exempt.
This is specifically talking about identifiable information of a dependent child,
Right.
not your information. So if you have, and correct me if I'm wrong, Tom, but if you have your child on a health insurance, that's what they're talking about. Can I get a public records request to get your child's information from your health insurance plan?
Okay, so that goes back to what Ms. Patrica had asked regarding the all, so it's not just pertaining to the child. I mean, it's only pertaining to the child, not to all. Okay, thank you.
Moving on to the first paragraph, under access to public records on page 2. That first paragraph identifies a records management liaison officer and a custodian of records. Do we have those employees by that title currently in the district?
Another board member actually asked the same question, and we have what we call a public records manager, so we've changed that title.
So that will be changed in this policy to reflect that?
Yes, it's
Okay.
already changed.
Okay. And then my second question on that was, throughout the policies, I noticed that when you talked about an employee being responsible for the implementation of a state law or a federal law, you also talked, the policy also addressed that employee being responsible for the implementation of this policy. So my question is, in that last sentence, should it be the custodian of records for the district who shall be responsible for implementing the requirements in state law and the state records management system and this policy regarding the public records maintained by the district? Just in terms of consistency across policies, that seemed to be what I was reading.
I'm not sure I understand the question, Ms. Patrica.
Okay, so in other policies, when we talked about what an employee is responsible for doing, we said they were responsible for implementing state law, federal law, and this policy, meaning policy
Right.
8310. For consistency purposes, at the end of this, at the end of this paragraph, it talks about what the custodian of records is responsible for doing, to include implementing state law and the state's record management program. Should we also say that that individual is responsible for implementing this policy?
Yes, I think that would be an appropriate addition, and this policy.
At the very end of the sentence?
Not there, I don't think.
Wherever it's grammatically correct. The requirements in state law, comma, the state's records management program, comma, and this policy regarding the public records maintained by the district.
But I'm going to weigh in. Mr. Chair,
Yes.
can I just ask the boards to consider why we would make somebody other than the superintendent the accountable party for the implementation of a board policy? Generally, you only have three. You have an auditor, you have a school board attorney, and you have a superintendent. I'll let Kathy weigh in, but it was just a flag for me when we start moving down the organizational chart and making other employees accountable to the board.
I hear that, but it's in other policies that I reviewed for today, in several other parts, so that was, this stuck out jumped out at me as being different. So go ahead.
There may be a reason why the employee is noted in the other policies. For example, a lot of our equity policies require us to name the equity coordinator specifically in the policy to be compliant with the OCR regulations. So I agree with the superintendent. The way that we have our public records structured, it falls under communications, then we have a chief of communications, we have a director of communications, then we have our public records manager. So I don't think it's the best way to move about. All of these individuals report up through the chain of command to the superintendent. So the superintendent is ultimately responsible to ensure that all of the policies are being met and staff is doing their job.
Okay, that's fine. I'll go back and pull out the other ones and we'll go the opposite way.
If I might, I believe that the records, the RLO is referred to in statute, and these specific duties are identified to the RLO, that you need to have one by statute, and these are his or her responsibilities. If you put in, if what you're suggesting is that instead of the RLO, you insert superintendent, as our definitions will indicate, when you name the superintendent, you say superintendent or designee. That's what you mean. So the superintendent may designate whomever he or she wishes to perform those responsibilities. But I believe that the statute refers specifically on the access, the public record statute, I believe, refers specifically to an RLO.
So that's why we do have the public records managers, what we call them here.
Right.
So that, we're not changing that, because I agree with you, the statute does require you to have somebody who's responsible. But in terms of enforcing whether or not the policy is enforced, and whether or not the public records manager is doing their job, I think that's
Absolutely.
the superintendent.
Yes, absolutely right.
If I may, as chair, it seems a little redundant to say you must follow all the statutes, which is what our policy is based on, and then say you must follow the policy. If you don't follow the statutes, you're not following the policy, and I believe it would be the superintendent's job from that point on. So I don't really see a need to add that at this point here. And there may be other places we need to take that out even.
Yeah,
that
and
reason.
that's what
I
I'm
mean, I
going to do.
agree.
I'll work it backwards.
Okay.
I'll go through and
All right.
point out the ones where it says responsible for enforcement of policy.
Any other questions?
Not on this one. I've got a couple more on the 8,000s, if I may.
Oh, yes, as long as you're on 8,000s.
8315. What does AP mean?
Administrative procedure.
So, Ms. Patrica, what will happen is, once the board has adopted these policies, Neola will release the administrative procedures that coincide with the policy. So we will have this policy is 8315, and then you have administrative procedure 8315 that will coincide with that policy. That's basically the process document.
Okay.
And if there were a form, it would also have 8315 and an F for form, so that you'll be able to track the policy to the procedure to the form if a form is required.
Moving on to 8325, please. Let me see my question. The first sentence, I'm not sure what it means. Pursuant to Florida law, in all suits shall begin against the board, legal services shall accept service or process on behalf of the board. I don't really understand what that
I
means.
think there's a word missing in that.
I think, Tom, in this one, and don't forget to use your mic, pursuant to Florida law, I think we need to take out the "in." It should say, pursuant to Florida law, all suits shall be against the board. They're the corporate entity.
Yes, I agree with that. Yes.
Thank you. I was not pointing out a Scrivener's error aloud. I really just didn't understand.
No,
what it
that's a
meant.
good call. We need to correct that. That was 8315?
8325.
That was 8325.
8325.
Pattern.
Moving on to 8330, if I may.
Yes.
Last paragraph, under limitation on collection and retention of certain information, is this paragraph necessary?
Which paragraph again?
I don't know, I gotta go back to my notes, I'm trying to open it. 8330, second paragraph, no, sorry, last paragraph, under limitation on collection and retention of certain information. Oh shoot, am I in the wrong policy? I think I'm in the wrong policy. My notes are wrong. Hold on, let me go back and look, please. Might be 8330. Yeah, I'm sorry, I'm in 8330 on page 3. I think Ms. Morgan has already addressed that, never mind. It's the palm scanner thing.
Yep.
I think that might be it for substance, hold on. Again, without line numbers, it's incredibly difficult for me to point out. All I have, like I read it and I write first paragraph and then I write next paragraph, and now I have no idea where I am. So I guess moving on to a more general comment here, and this is something that my newer colleagues might not know, but it's something I'm particularly sensitive to because I'm a parent and a guardian, and that phrase is not used consistently throughout. It's either, sometimes it's we're just referring to parents, sometimes we're referring to parents and guardians, and at the beginning of the policy, there's a definition of parent to include guardian, so I'd just like some consistency there. Either we refer just to parents, or every time we refer to a parent, we refer to a parent or a guardian. I know that when I read something and it doesn't say guardian, I feel like I'm not included in that. You know, like a whiny baby, I'm not included in that. Does that make sense?
May I?
Yes.
If we can just be consistent through that and just say, you know, parent and or guardian in each relationship, because I mean, it should definitely have the word parent. But as we all know, not every child has a parent who's responsible for them.
Frankie, did you have a comment there?
And Frankie, don't forget to use your
Frankie suggests that
your mic.
the definition section defines parent as parent or guardian. I'm reluctant to say that, well, I suspect, without checking each reference to parent and or guardian, that that's the way the statutes read. Some have parent in it and some have parent and or guardian. I agree that there should be consistency. I suspect that there is not consistency in the statutes. That does not mean that there should not be consistency in the policy, as long as it doesn't change the meaning.
I don't think it does change the meaning.
I don't think it does either.
Yeah. Neither do I. Ms. Jordan?
I was just going to say, most of this does say, it does include parent, guardian, or eligible in the most of this 830, 8330. And I think that at the last time when we were going through all the other policies and everything, I think we kept referring to making sure that we were including everyone, because of the fact of the matter is we do understand that there are children that do not have a parent per se, but they do have that guardian.
Right.
So I know that we spoke about that, as Mr. Chica said, prior to today at other meetings. But in most of this, it does state parents, guardians, or eligible. Thank you.
Is there a place in this, in 8330, where it is inconsistent, Ms. Petricka. Did you notice?
Oh, yeah, it's definitely inconsistent. I made several notes
Okay.
about that. So I think that
Within 8330.
within 8330 is what I'm
Okay.
looking at right now, yes. There are times when parent is mentioned without guardian.
Okay.
So just a simple, find and replace in there would be great.
Hey, Frankie, are we able to do find and replace through board docs?
Yes, I think so.
Okay. So the Neola champions, please be mindful of that when we're going through the rest of the policies.
Ms. Patrica, do you have any other?
Yeah, I think I found the paragraph that didn't make sense to me. We're looking at access to student records, page 3, the third paragraph under access to student records. My notes tell me, I do not understand this, it seems contradictory, question mark. So let me read it and see what schools may.
During the third paragraph under access to student records, is that right?
Yes, schools may without consent of parents. Reading it now, it makes sense. I don't know why it didn't make sense in my brain when I read it. So we can ignore that. If I have questions in the future, I'll bring them up with Attorney Dupree Bruno, please, and thank you. Those are my comments for now.
Okay. Mr. Fisher?
It was just a follow-up to Ms. Patrica's comment on that. I saw some of the consistencies as well as with some other definitions, but I figured if we just had the definition that's controlling in the beginning, so I kind of figured keep that as the catch-all in the cover. That was my comment.
Yeah.
Any other comments on 8,000? Seeing none, let's move to the 9,000 policies, community relations. Do we have any questions? Give you all a moment. Mr. Fisher?
Thanks, Chair. I had discussed this with Attorney Dupree Bruno before under 9160, and they're currently looking at this. I just wanted the board to be aware. Down, I gotta remember, it's the public attendance at school events, and going down to, I believe it's in the last paragraph. Sorry, let me refer to my notes on that. Talks about filming and public event. I asked both under how that's affected by both privacy as well as what is defined as a public event. So I know, I just wanted to convey that to the board that I know they're going to be following up on that. I just wanted the board to be aware of that, because those were my two questions, because there's two angles on that.
Thank you. Other questions? Ms. Morgan?
So 9140, and these are taken from our policies, and I think that we are not doing what our policies call for, so I want to bring these to the attention of the board. 9140, the chair and vice chair may only serve 2 one-year consecutive terms in order to allow others to have the opportunity to serve in a leadership role. This has, in my opinion, has not been the advisory committee practice or DAC practice. Is this what we want?
So let me just clarify one thing, Ms. Morgan. So there was a recommendation that the vice chair and chairmanship follow the term limits of the board. So this is a new proposal for the board to consider, exactly what Ms. Morgan said. Does the board want to do that? But it was not in the prior policy.
And again, this is not something that we need to necessarily decide on today, but as long as we're talking about policy, I think we ought to recognize that there are things in here that we're not doing, and do we want to bring these forward? Further on, it says, prior to the beginning of each academic quarter, the superintendent shall establish and inform the board of the quarterly input subject. And at the first monthly meeting of the corresponding quarter, each board advisory committee, blah, blah, blah. While I agree with the statement, this has not been the practice of the board, again, for 10 years, at least the 10 years I've been on the board. Occasionally, requests are made of committees, such as EDAC's review of the Code of Conduct. But again, this is something I think we need to talk about and, just look at.
And that one, Ms. Morgan, just so I can make sure the board knows, this is in your current policy.
Right.
This is language from the current policy.
And then and this is again, current policy, under construction advisory, it says the construction advisory committee shall consist of 16 members. 1 member shall be appointed by the head of the Fire Chiefs Association to serve for a 2-year appointment. We're not doing this. Then under E, continuous systemic improvement advisory committee, it says, it cites, it shall be, an effort shall be made to ensure balance of parents, community members, and persons who have experience or certification in Lean Six Sigma. Now, we've taken that out of the job descriptions, and I'm wondering if this needs to come out because it's no longer a district priority that we're working with people who must have or should have Lean Six Sigma. And then, I'm sorry. Oh, yeah, that's it. Those are all in that one.
So if we could just know whether or not the board wants to remove that language with regard to the Lean Six Sigma, so that if you do want it removed, we can remove it.
I personally feel it should be removed.
I'm just showing my agreement.
Okay.
Anybody
All right.
opposed that?
Be opposed to removing that? Okay.
So Frankie,
Yes,
can you make that
Tricia.
correction? Please?
If I may, through the chair, ask to Ms. Morgan's other questions, if we don't discuss them now, when do we discuss them?
I'm just thinking we can discuss them after Tom leaves.
Understood.
And then finalize what it is we want to do. We don't, rather than use his time. 9143. Oh, I'm sorry.
Excuse me a second. Counselor, are you in?
Oh, am I? I'm in. Sorry.
You are. That prevents Frankie from making that
Sorry,
correction.
Frankie. I'm out.
It'd take a minute for this to clear.
Minutes so that the computer understands that they're not two people trying to get into the same.
Sorry. I'm on board docs. Sorry.
No, it's okay.
It takes,
I don't understand technology at all. One of the things I don't understand is why the cloud sometimes instantly provides access to junk, and yet when we're trying to work something out here, it takes 2 minutes for the cloud to direct it to us. So, anyway,
okay, let me find it. An E, right?
I am old and not technologically savvy.
I'm taking out or certification in Lean Six Sigma. Correct?
Yes, thank you.
Your patience, board members.
Ms. Morgan?
Okay, 9143 is about ISOC. The committee oversees the use of sales tax revenues in accordance with Exhibit A and provides periodic reports of such use to the board. And then, and Attorney Dupree Bruno and I had a conversation about this. I don't think we've made it clear when we want the ISOC chair to present to us, when staff can present to us, how we are updated and when. And that may just be a process document, but That has not been taking, again, that has not been taking place, so it's something we need to address. And then under section B, the board chair and superintendent shall each select one alternate to be appointed by the board. Alternates shall be appointed for 4-year terms. Alternates shall attend committee meetings. However, an alternate shall not have voting rights or the right to make an official decision of the committee. One, I don't think we have alternates. In the event that a regular member of the committee resigns or is otherwise removed, an alternate shall serve the remainder of the regular member's term. Now, when General Dozier informed me that he wished to leave the committee, I worked with a staff member to go through the applications to find someone to replace. I didn't know there was such a thing as an alternate, and so I violated this policy. And then it goes on to say, the alternate chosen by the board chair shall serve as the first alternate until elevated to regular membership. So again, in talking to Attorney Dupuy Bruno, we agreed that there needs to be a process document in the board office, in the superintendent's office, for all of these committees when there is a transition, so that staff can appropriately direct us, because my bad, I didn't go read the policy. I just worked with a staff member to bring somebody on board. So I wanted to bring that to your attention. And this is 9143, I guess. Under 9143, oh no, 9200. I'm sorry, 9200. A school volunteer is any non-compensated person who may be appointed by the superintendent. Now, as far as I know, and again, Attorney Dupuy and I had this conversation, the superintendent isn't appointing school volunteers. Principals are, and they have state statutes, federal statutes that they have to comply with in order to make the appointments. The question is it implicit in this that the superintendent is delegating the authority to do that to the principals? Or is this, so again, that's, do we want to clarify that? Now, I think you said, Attorney Dupuy Bruno, that superintendent is defined in the definitions as a superintendent or designee.
Or it implies that the superintendent is able to delegate.
Is able to delegate.
Yes.
I just, again, that's a small point.
So to add to Mrs. Morgan's comments, there has been some, and Tom, if you could answer this, there was some questions that were raised whether or not policies needed to say superintendent or designee. I know even in our little workshops we've had that discussion. So if you could explain to the board the definition and how it applies.
Yes, in the definition section, the word superintendent is defined as the superintendent of the district schools, and it clearly indicates that the superintendent, when it's used, also means superintendent or designee. So the definition section of the policy manual clearly indicates that when superintendent is used, it is either superintendent or designee at the superintendent's discretion. Now, there are some places where you might want to identify a particular individual. You can do so. In this one, for example, I confess my ignorance. Would there be times when the superintendent himself or herself would appoint volunteers? Is it always only the principal that appoints volunteers? If you say superintendent or designee, you leave the option about who it is that appoints volunteers to the superintendent. And I think that flexibility is appropriate here.
Mr. Dupuy Bruno, I have a question on that also. What about a removal of a volunteer? If we just said principal, would that
So
forego the superintendent to be able to remove someone that was brought up.
Right. I think that Mr. Young's suggestion will capture that as well, because there are times that it may not be the principal that's removing a volunteer. It could be a central office removing a volunteer. So maybe in this particular case, we put superintendent or designee.
Ms. Patrica?
Well, I was going to say that begs the question of consistency again, because I understand why you read it the way you read it, because in other parts of the policy, it specifically says superintendent or designee.
We tried to delete that every time we see it.
So I get that the definition covers it. That being said, if I'm reading this policy in a vacuum without, I'm a person out there just reading this policy and I haven't read the definitions, I'm thinking it's only the superintendent. So either we remove or designee everywhere, or we put or designee in everywhere for consistency purposes. That's.
And I will say to you that we attempt every time we see or designee to delete it. If you find it somewhere, bring it to our attention and we will delete that.
But then, so this will cause the concern that they're raising in this particular policy. It makes sense to have superintendent or designee, and some of the other ones, it may not make sense. So we may not be able to do superintendent or designee across the board in all policies. I think we have to do it policy by policy in terms of what makes sense. And in this one, I think it makes sense.
Mr. Fisher, you had your hand up?
Just based on what's being set up here, Attorney Dupree-Bruna, I still think we should just leave it with what the definition is. Then I think we're just going all over the place if that's the case. So I think it just simplifies keeping whatever the definition is in the definition section and leave everything else up to that.
Any other comments on this one, or?
So the only thing I would add is when you're looking at a statute, normally when you're looking at a chapter, the first part of that statute is going to have all of your definitions in it. And then as you read it, you're going to be able to pick those words out. So we just need direction from the board, because I do understand what Mr. Fisher is saying as well, to go, just to explain on behalf of staff that's been working on this, Board Docs is not the easiest platform. It's not Word, where you can, it's not easy to use. So for staff to go back and find all of the areas that have superintendent and add designee, that's going to be a lot of time expended on just that versus them concentrating on the subject and the meat, if you will, of the policy itself. But if the board's desire is for us to do that, then we will do that. But again, that's why the definition section is there. We just need guidance as to what you want us to do.
So can I have a consensus here whether we should keep it superintendent?
I have a question if I
Yes.
may. So are there times when it is just the superintendent?
Yes.
Then the definition doesn't cover it because the definition says superintendent or designee.
No,
So
no, no.
if there are times when it's just superintendent.
So, no, because the word superintendent, when you're reading the policy, you're going to take it in the context of what the policy says. So in this particular policy, we're talking about volunteers. We have, 112 schools. Superintendent and all of the volunteers that work in all of those 112 schools, plus whoever is here also in the central office, superintendent cannot be expected to approve all of those volunteers. It's just impossible. So implicit is that the superintendent is going to rely on his other staff to assist him in almost all of his duties, really. All of his duties, he has to rely on certain staff to assist him.
I understand, but I don't think that answers my question, because if there are times in our policies when only the superintendent can do something, but we're relying on a definition that says superintendent or designee, then the definition doesn't cover it.
It says superintendent may delegate. That's what the actual definition says in the bylaws. So it's implicit that the superintendent is responsible, but if the superintendent needs to delegate, that he's able to delegate.
And that would be true every time the word superintendent shows up in our policies.
Yes.
Then the definition would cover it, and we should be removing or designee whenever we can.
Okay.
Is that the
Ms. Jordan?
consensus of the board then?
Ms. Morgan and Ms. Fleming? Okay, just leave it superintendent, please.
Good.
If I may.
Yes.
If I may push back a little bit on my colleague on the parent or guardian thing. That's more of a, if I'm a parent or if I'm a guardian reading a policy and a sentence refers to a parent and then the next paragraph refers to parent or guardian, I think that second paragraph is the only one that applies to me, as opposed to understanding that parent applies to guardian. Am I making sense? Like, I'm trying to think of it from the perspective of a parent or a guardian. If I have a question about, I'm a guardian, I have a question about my kids' records and whether I can access them, and parents are allowed in some paragraphs to do it, and parents and guardians are allowed in other paragraphs, I'm not necessarily looking at the definition, I'm just thinking, oh shoot, I can't get their medical records, but I can get their report card. You know what I mean? Am I making sense?
Yes, but then I think then it should just say parent and be consistent back if you're going to do it that way.
But the personal piece of it is the exclusion of me as a guardian from the policy altogether, and that's what we had talked about previously. It's an emotional thing.
Okay. Did we take a consensus on that one before? To leave it at parent or put parent and guardian? I can't remember. Okay.
So board members, for staff, if we're going to rely on the definitions, I would ask us to rely on the definitions, because there may be other words here that we need to go back and forth. So I think however you direct us to do it, we're going to do it, but we do need some consistency so that staff is not spending a lot of time going through all these policies to find words and substituting and adding.
I would be for leaving it as parent, but somewhere we need to, in bold letters, put the definition as parent, not just somewhere where someone may not see it. Maybe somewhere at the top of this policy. You said they would show up to the definitions, but I'm not sure exactly how that works.
So, Mr. Young, can we put the definitions in front of every section of each book?
That would,
I don't think that they would do that.
that would change every template. One of the ways to deal with this would be perhaps following up on the chair's point. At the beginning of 8330, which is the policy that Ms. Petricka brought to our attention, it might make sense, would make sense, to use in the very first sentence perhaps, or the first time parent is used, that in that policy, parent means parent or guardian in that policy. There are other places where parent or guardian may not be appropriate. So
The only,
to the extent and that would be defined, by the way, parent would be defined as parent or guardian as appropriate in the definition section. But in this section, to Ms. Petricka's point, if you're a parent and you're looking at 8330 and the only thing you see, if you're a guardian, and the only thing you see in 8330 is the word parent, you may not know to look at the definition section.
so the only caution that I have is for my academic services team that has the 2s and 5s, which are hundreds of policies, that they're going to have to go back and try to find everything that says parent and guardian and fix all of those policies, because there's going to be other policies that will have that in there.
I understand your point, and I guess the question is whether or not it is sufficient to have parent defined in the definition section as parent or guardian, which is what we've done with every other district.
Perhaps we can have in those 2s and the 4s specifically, this 8330 is a strange one because it popped in under operations, but maybe we can just have something in the beginning that just notes what a parent is, maybe. I think this is a conversation for offline, and I want to talk to the academic services team. So we will look into that, board members, and try to see if we can find a solution.
Thank you. Ms. Fleming, you had a comment?
I just think it needs to be consistent across the board, because I can't think of a single thing where, I can't think of a single time where if a child needs guardian permission, and that is a child, whether they're in foster care or not, they always are going to need guardian permission. I can't think of a single time where a guardian should be taken out. So perhaps in the definition itself, it says parent or guardian. And I understand what you are saying about your template, but down at the end of each one of these policies, there's kind of a notation area where it says legal. Why can't we there in fine print at the end of every policy, almost like a notation of parent, the definition of parent is da 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 on any one of these policies? Just so that it's right there if I was a parent reading this, or I was a grandparent who's now the guardian of my grandchild, if I keep reading through the policy, I can say, oh, now I see, I am able to get the documentation.
So I think it's important to be clear with regards to what the definition is and what the definition actually says. Parent in the definitions, I'm sorry.
I was just saying, I don't think that it's necessary to go changing the format of the Neola policy because of the template situation. So in fine print underneath, if we could have the consistent definition at the end of every policy, especially something with that's having to do with parents or guardianship.
So one thing, we can be legally correct by saying parent means parent and guardian, but not being clear to the people reading the policy, and that's who we really are going to be reading it. So whatever is the simplest way to get that definition across to the parents and guardians that it is both a parent. We'll leave that up, like you say, till later, if you'll meet with them.
Yeah, that goes back to the team.
But I'm sure that's the wish of the board, is to make it clear. But not necessarily change every single place where it says parent. That would be very tedious on every one. Okay, moving on. Any others? Comments on the 9,000s? Seeing none. We'll move on to the bylaws. Ms. Dupay?
Okay, so the board has had an opportunity to review this a few times. We've had some prior workshops. So the first set of documents we're going to review will be the actual bylaws. So Mr. Young.
Board members, at previous workshops, we reviewed the bylaws. You made some changes in some. There was consensus on some. There were numerous instructions to your attorney, Ms. Bruno. She has, it is my understanding, made the changes that you've recommended, and I understand that you have had a chance to review them. There's a lot of new ones here. You see new, that's your language, not Neola's. It's totally up to you. I will generally have no comment on those areas, new policies, unless you ask me a question. My answer will probably be, board members, whatever you say is fine with me. These are your bylaws. These are how you operate. Having been a board member, I understand how useful a good set of bylaws can be regarding the conduct of your business. But they're your bylaws.
Okay. Members, comments on and questions on bylaws discussion? Yes, Mr. Patrico.
This might be one for when Neola's done. I wanted to go through 156, legal counsel. But this might be a discussion for when Neola's not here.
Well, this part of this is Neola language, so we probably need to go through it.
It's not Neola's language.
I think this is, no, wait a minute, this is the wrong policy. That's the wrong policy number. Attorney Dupree Bruno, can you help me with the policy number of the reimbursement of attorney's fees?
Oh, okay, sorry. Let me, it does not have a number, it's actually 6490, but we put it in bylaws.
It's called Legal Services for Employees, Officer, and Public Officials.
So this policy, your template, Neola, is 6490, however, we moved it into bylaws, and we would have it in bylaws as well as in the 6,000s.
So do you all see it, my board members, my colleagues, do you all see it?
Yes.
Okay, so I had a couple of questions. And unfortunately, I didn't take notes on my questions on this one. There was one part where I felt like the elected superintendent was left, it's the very, not the very bottom. Second to the last page, the green, the full green paragraph at the bottom. Board members may request that the board indemnify them, blah, 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 blah. Why, can't ethics complaints be filed against elected superintendents as well?
Yes.
So why would we restrict that just to board members? Why
we-
wouldn't we include the?
We can add elected superintendent.
Okay.
So just,
Typically, this policy is for a district that has either an elected superintendent or an appointed superintendent. It's my understanding that this district has currently an appointed superintendent, but it is going to an elected superintendent. So adding elected superintendent here would not be inappropriate.
And can appointed superintendents be the subject of ethics complaints? So I think we should have both in that paragraph to protect the superintendent, the appointed superintendent, until it changes to elected. Are we good with that?
Yes.
That's one question. The other question I had for the board, and this is where I think Neola should be gone, is I have been trying for the better part of 2 years to be reimbursed for various ethics complaints that have been filed against me and dismissed. And I'm wondering, Attorney Dupree Bruno, does this policy as written clarify the questions that have been asked up to this point?
I believe so.
So as soon as a complaint is filed, in an ethics complaint, if any of us get counsel and that complaint is dismissed ultimately, we can get reimbursement, yes?
And that's exactly what the policy says.
Okay.
Once the ethics complaint is dismissed with no findings, you can be reimbursed.
Okay, the only problem that I have for you all is if we approve this policy, I only have 30 days for reimbursement, but some of these complaints go back years. So may I apply for or ask the board for reimbursement under our current policy, which doesn't have a time limitation in it, and then going forward, we have to request within 30 days. Is that something I may ask of the board?
Would we
that-
have to take a vote on that, being this,
Yes.
at
I'll
a
bring
different
it.
meeting?
I would bring it at an action meeting.
Yes.
For sure.
That's why I would-
But I just want to make sure the board is okay with that.
Okay, will you bring it forward?
Okay, I'll bring it up at the next board meeting. Thank you.
So, Ms. Patrica, what I would recommend is that we do an agenda item, and then we add all of that, and then submit it to the board for approval.
So I'll get you the comprehensive attorney's fees over the past several years that have all been paid, and it shows by case number what was done.
So, just for my clarification, I think the one that we had talked about before was one from last year or a year and a half ago. I don't know. I don't know about anything else, so if there's
There are
others.
a total of 4, one of which was dismissed 2 weeks ago, probably.
Okay, so you probably need to bring all of them so we can,
Okay. And I thought that this policy was really good in the sense that it addressed more than just ethics complaints. It addressed litigation in general. I thought it was a good policy, so thank you for bringing this forward. Those are my comments, thank you.
Frankie, if you're in that policy, you see at the very bottom, prior to end of option 1, where it talks about, it's in green, board members may request, all the way at the bottom. Go all the way at the bottom.
There's no check in this box after
It's
option
further
1. Do you
down.
want it checked?
Which one?
Accordingly, a board member or elected superintendent, the first one doesn't not have a, it's not been deleted or have a check in it.
Which one? I'm trying to follow. It says, yes, it should be checked.
All right.
And then I have a question. Can we remove the word elected and just leave it at superintendent? So then can we do that, Frankie? Take out all of the elected and just leave it at superintendent?
If that's acceptable to the board, it need not be appointed or elected. Superintendent is superintendent.
I think
Correct.
that makes sense.
Yes. I'm seeing all yes heads here, so go ahead, please.
Ooh, I can't tell.
I think I have one more question, if I may, for Attorney Dupree Bruno. Looking at the top, and I think I know the answer, but I just want to make sure. Number 3. The board member or the employee's acts or omissions which are the basis of the claim are not predicated on or arise out of bad faith or malfeasance. You would have to have an actual finding of malfeasance in order for, like, you can be accused of malfeasance, but if there's no finding of malfeasance, then you can be reimbursed. Because this indicates arising out of bad faith or malfeasance. The accusation can be based in that, but if the accusation is not found to be true,
So,
is my question making sense?
Remember to read the first part. We're talking about legal claims, actual claims, legal claims.
Right, no, I get that.
So it would be legal claims where, based on the act of the employee or omission, it's predicated out of malfeasance or bad faith. So basically, this policy is not going to defend an employee if they are bad actors in a legal claim, in a lawsuit.
But what if the accusation is malfeasance, but that accusation is not proven? Does the employee get reimbursed in the end?
But it has to be, so let me process what you're asking me. Repeat what you said.
So there's a part in the policy later that says if we pay for attorney's fees up front and the individual is found, I think the word guilty is the word that's used, then they have to pay back the attorney's fees. My question is, it looks like we're not going to pay for attorney's fees if the accusation is based in bad faith or malfeasance. What if at the end of the proceeding, the lawsuit, the employee is found to be completely cleared of all charges? No malfeasance took place, no bad faith took place. Can that employee at that point seek reimbursement when they're cleared?
Yes,
And that's later in the policy?
yes.
I just
Yes.
wanted to be clear on that. Thank you.
And then Frankie, did you see that last part there? After, or right before the end? Nope, go up a little bit. Go up a little bit more, Frank. Oh, you're getting all the elected.
There's another elected in there.
I think you were actually reading that. I thought you were.
I'm trying to follow.
Okay, what do you need, Kathy?
So if you go down a little bit more, further, okay. I believe that says board members may request at the board. Is that correct? I'm having a hard time reading it. from your screen. Is that where it says board, the green section, board members may request that the board indemnify them for attorney's fees?
That the board identify them for
We
attorney
need to
fees.
add board members and superintendent.
Okay.
Thank you. And honestly, because this would be Florida Commission on Ethics, it could be anyone that falls within those ethical boundaries. So it could be our CFO, it could be any person under that. So maybe board members and superintendent and staff that fall within the Code of Ethics from Chapter 112.
Thought I did all these.
Is that okay, Tom?
I think so, yes. Struck the wrong thing there last time.
For some reason, they didn't take the first time. Okay. Okay, I think we got it.
Okay, do we have any other questions on the bylaws? Mr. Fisher?
Thank you. I went through most of these with Attorney Dupree Bruno, but I had a question, I guess, for possibly Tom and the board. Going back to definitions section, under social media, it talks about social media or online platforms where users engage one another and/or share information and ideas through text, video, or pictures. Social media consists, I guess that should be, of any form of online publication or presence that allows interactive communication, including but not limited to text messaging, et cetera, et cetera. I would argue that definition feels overly broad to me, including with the text part, especially if we talk about trying to just talk and, you know, simplify things, going around with the spirit what we talked about before. So I don't know, just unless I'm reading it wrong and reading it through some of the other policies, when I look at stuff, I don't think of text messaging and social media to be the same thing. So I think it's too much of a catch-all, but that's just my thought on it. I don't know if the board agrees or maybe how you guys looked at this, Tom.
Oh my gosh, thank you.
Yeah, I forgot it was on our screen.
If you give me a second to read it, I can respond. Thank you.
Oh,
Because in some of the ones later on, they separate email and social media, but I don't know, I think texting or those communications are a separate category, but
Okay, where is that in the definitions? Which definition is it?
social media.
I'm looking at that. Okay, I see text messaging the second line. I'm looking at text messaging.
I just felt it was just an overly broad definition. If you're looking at the plain meaning, and that's what we're trying to do here, and I'm trying to train myself to do the same thing, when you think of social media, you don't think of that. But again, I mean, it's, go ahead, sorry.
If I may, Mr. Chair?
Yes, please.
I would agree with you. I think that instant messaging is what we're talking about in a social media context. You don't text on social media, you instant message on social media. Or at least that's what my kids tell me all the time.
Because if you're looking at, you know, a policy or something, you see just social media, most parents are not going to think of that as text messaging or something to that extent. That's what I'm trying to argue with that.
I think you can change the definition if you wish. Someone else more knowledgeable than I in this field came up with this definition. And I think it was their intent to make it as broad as possible. I think if you delete text messaging, I don't think you're doing a damage to the templates in which social media is referred or referenced. I suspect in the context of each individual template or policy where social media is used, there will be an understanding of whether it includes text messaging or not, but I don't know this to be true. I'm just saying, this was a definition that was approved by Neola, and there is no rule of law, I don't think, which defines social media and that must include text messaging or not. I think that's a board discretion.
Thank you. As I said, I'm not overly concerned about that. It was just something I noticed. I've dealt with a lot of social media and law before, so it's a little bit of my wheelhouse. So I just felt it was overbroad. But as I said,
Sure,
it's
you're
not
more
something.
knowledgeable than I on that point.
So
And if you take it out, if you take text messaging out, would you need to take out the word text in the first sentence?
no, because I mean, if you're looking at text versus text messaging, again, as I said, if the board, it was just a note to the board. Maybe I was overlooking or looking too much into that.
Ms. Jordan?
I think we should just leave it in there. Because what they send through their phones is the same. It may not be Facebook or whatever book that they're using nowadays, Instagram, TikTok, whatever. They can certainly text pictures and everything else out to whomever, which can then go further and further. So I would recommend leaving it.
Which I'm fine with, but I would still argue that's not social media, with what you're describing. But I'll withdraw that.
Any other comments on that?
I know that Mr. Fisher had a few other, sorry, I'm going to another policy, sorry.
Okay, so it seems we just leave that in as it is. All right. Any other discussion on the bylaws? Okay. Oh, sorry, Ms. Jordan.
I just had the part of the bylaws where it is the audit. I thought we were going to put in, like, the audit committee. I did not see a, where if you miss X amount of meetings, in all of our committees, they're required to make the meetings because you're making that commitment to these meetings. So I thought we were going to make sure that all of the committees, if someone is going to commit to the meeting, that they need to be there. And if they miss X amount, then they would be removed just as they would at any of the other committees that we have.
So I believe
I didn't see that on there unless I just,
it's 75%, but let me just double check.
okay. I just read it again and I didn't see that. That's one of the new ones.
Right, so the new ones are the policies that we currently have that we just brought over to Neola so they can be part of the adoption. Because they don't have this policy, so let me just double check.
Right, and so we did not have that. Originally, there was nothing on for, there was two committees that we had not changed, and that was the audit committee and the oversight committee, where it did not matter if, they didn't have to show up for the first one. But if we have their names on there and they are someone who we have representing and giving us advice back, I think that they should be present. Just like the other ones are required to be there.
Yeah,
And I'm sorry, it was the audit committee, the new ones.
Right, the new committees. I concur, we should definitely have consistency throughout all the committees as far as attendance for the members. So if that's not in there,
What is the name of the policy, please?
It is the, it's actually audit committee,
Okay, got it.
and it's one of the new ones. Unless I'm just overlooking as I'm reading this again, I do not see anything that states And that's the same with our oversight committee as well.
So, Ms. Jordan, it's actually under meetings, subsection D. To remain a member of the committee, voting members must attend at least 3 meetings each year.
I am so sorry. I read this, I can't even tell you how many times I looked this, just over. And is that the same that's on the ad hoc, on the ISOC as well?
ISOC, I'll have to go back and look at that one.
Thank you. I apologize. It says to, I'm sorry, if I may.
Yes.
It says to remain a member of the committee, voting members, to be able to vote.
So the voting members would be all of those that the board has appointed. The non-voting members are your CFO, superintendent, and myself, and the staff liaison. Those are the non-voting members, but everybody else is a voting member.
Okay. Thank you.
Any other questions on the bylaws? Seeing none. The next item on our agenda is a review of the February 22nd, 2023 regular agenda.
Mr.
Doctor-
Chairman,
Yes, I'm sorry.
may I make the assumption that we are excused?
You may. Get out of here. Have a safe trip.
And board members, thank you for your continued involvement in this process. We appreciate your vigilance.
Good job.
Mr. Preber needs a question.
Mr. Chairman, so at this point, and before you leave, Tom.
Yes, ma'am.
The 8,000s and the 9,000s, they're going to be cleaned up and finalized for the board. Does the board want the corrections shown to them when we do first reading?
Yes, please.
And do you want the corrections from today I'm sorry, the prior corrections, or I think we only have the corrections from today. So when we bring them back to them on the first reading, they want to see the track changes.
The first hearing.
First reading in June.
Hearing. Okay, that'll be the first time we've ever done that, but if that's the board's wish, we will do so.
For all the bylaws or just the ones that
This is for the 8,000s and 9,000s. Whatever was changed today, they want to see them again for the first reading. And then I want to know from the board, we have not had an opportunity to provide you with clean bylaws. We've gone through these bylaws, I think now this is the 4th time we've gone through them. Does the board want us to provide you clean bylaws for the first reading, and do you still want to see all those track changes?
I personally don't need track change.
Yeah.
Did some change occur while I was back there? No.
I don't think so.
Okay, then what we have in front of us today is what we're going to be voting on, so then a clean copy. As long as no new changes are made. As long as no new changes are made, I don't think track changes are necessary after this.
So then for the first reading of the bylaws, there will be clean copies of the first reading of the bylaws.
Yes. Consensus? Yep. Yes, please.
So I just for my clarification, board members, for the 8,000s and 9,000s, we did those changes here. Do we also want those to come back with the track changes, just to make sure that I'm clear with the direction? Yes, for the 8,000s and the 9,000s. Okay.
Okay. Excused
Thank
for a
you.
second time. Dr. Bernier.
May I have,
Yes.
may I have just a 2-minute recess so I can just walk them out?
Sure.
Thank you.
Let's recess for 2 minutes, or about 5 minutes. Recess. We will resume the meeting. The time is 1:45. Dr. Bernier, would you please do the agenda for the February 22nd, 2023?
Mr. Chair, members of the board, we've had several questions, mostly surrounding the consent operations agenda. That's the L section of the agenda. L5, approval of the award ITN number 5227439MG, Program Management Oversight of Permanent Facility Repairs. The question from the board member was, what is the purpose of this company? Can you please explain in detail what this company is going to do? Due to the increased volume of permanent repair projects that must be completed as a result of Hurricane Ian, the district is seeking to utilize a program management oversight team to assist the district with managing and coordinating these permanent repairs. Some of the tasks awarded to the vendor will perform, some of the tasks awarded to the vendor that they would perform will include coordinate contractor work schedules, monitor all of our budgets, create a communication plan regarding progress, conduct field inspections to validate compliance and repairs, anticipate and escalate risks, advise on risk mitigation strategies, validate compliance of other contractors' invoices with requirements of federal and state disaster recovery programs. In addition to the need for expediency to implement permanent repairs, the permanent repairs must also be documented in sufficient detail to comply with federal and state public assistance programs to be eligible for reimbursement. So, in short, we have a lot of work to do and an extra set of eyes regarding ensuring that we are actually completing the work before we submit an invoice, making sure that our invoices have another set of eyes before they go to Imperium. Imperium will be the final I dot or T crosser, but now they can bring it back to someone who can continue to work on it while staff is able to proceed with those repairs.
Any comments, board members, on that? Okay.
So there were some additional questions about this particular item, but I wanted to stop there and sort of give it to us on a Valentine's Day chocolate box. We'll pick different ones. Why do we need another consultant? I think I've explained that, but the program management oversight vendor is needed to assist facilities maintenance construction staff with those permanent repairs. Why are we not using a local contractor? Local contractors did have the opportunity to submit for this ITN. This ITN was advertised on the district's procurement website using the district solicitation system. 81 vendors were notified of the ITN and 4 vendors submitted a proposal. Additionally, a contract awarded utilizing local vendor preference is not necessarily reimbursable by FEMA. The contractor working as the program management oversight consultant is not able to participate in the design or construction of permanent repairs, as this represents a conflict of interest. Because of this, many local contractors expressed unwillingness to submit due to their willingness and desire to participate in the permanent repairs. So while we have other people within the community who have great general contractor experience who could have helped advise us in this role, they have expressed did not apply, and in the people not applying, they did express a desire to be more involved in the actual permanent repairs as the contractor than others. So those are the answers that I have regarding item L5.
Are there any other items you wish to?
There's one other item, sir, L7, approval of Phase 2 total project cost estimate for Franklin Park Elementary School rebuild. Can you please advise when the rebuild process will start with Cypress Lake Middle School? There's been no discussion in quite some time what's the holdup or what's going on. The original schedule for Cypress Lake Middle School has the contracting phase going from fall of 2022 to the winter of 2023. District staff has completed the procurement process and are currently ready to begin the negotiation with contractors and are on schedule for an August 2026 opening. So the scoping phase was to be done in the spring of 2022. The RFQ was from spring of 22 to the fall of 22. The design is from the spring of 23 of this year to the fall. Then construction begins in 2024 till June 26. That's that 2-year window which takes to build a school building, and then the open of August 26 for school year 26-27. I have all this information. I'll be happy to provide it in a board update to all of you. But the Cypress Lake project is continuing to move, even though despite the damages that occurred during Hurricane Ian, which will require some repairs before we can ultimately tear them down and begin that rebuild process.
Any other questions on that? All right, board members' comments. Mr. Fisher.
No comments today, except for Happy Valentine's Day, everyone.
Thank you. Ms. Patrica?
I don't have a comment. I have a discussion that go to the order kind of discussion that I wanted to have with the board and the board attorney, if I may, regarding confidential information that the board needs to see, but is not being shared with us in an electronic format. My new colleagues don't know how much I hate paper. I despise paper. I don't read as well on paper as I do on a computer, number one. Number two, my schedule until the end of July requires travel at least twice a month. And I was in a position recently where I had to read one of those confidential reports on a computer sitting in my car in another state. Why? Because I couldn't get an electronic copy of it. So I'm wondering, it's my understanding, if I may, through the chair to the board attorney, the concern about sharing confidential items with the board electronically is the potential for a leak. Is that a fair assessment?
So there's two things there. So sometimes we have reports that are actually not necessarily provided to the board, and the board members read them through my office. And then there are times that information is provided to the board, but we're providing a hard copy because of issues relating to emails being forwarded and things of that nature, yes.
Right. So I feel like, I mean, I've never leaked a confidential piece of information ever, and I feel like I'm disadvantaged in terms of my access to information, as we all are, because we're not permitted to have this information electronically. So I'm wondering whether there's a solution that we could find as a group so that some of us aren't disadvantaged by travel.
I personally am worried about leaking. I've only been here a short time and already have seen things come out. I know if there's a report that's going to be taken further up the chain, that needs the most protection, so it can be investigated fully by other agencies. Reports that are final, I don't see really any problem, because that should be able to be made to the public anyway with the Freedom of Information Act. So those should be, I don't care how they are, but I've only seen one report so far that we're sitting further up the chain. And that really worried me, because I want it to be investigated to the fullest. And that's why I thought it'd be better to read in the SCIF and not have copies floating around everywhere. I mean, I'm open to suggestion from the rest of the board. I don't think there's going to be a lot of times we can't do it electronic. Am I wrong, Attorney?
I think the only time that we've had an issue is when we have a very sensitive and confidential report. So the one report that Mrs. Patrica is referencing, board members, no board member has a copy of that report. Everybody read it through my office, or accommodations were made for individuals to be able to read it. Another report that was submitted was emailed to all board members. It was a final report, so I'll take my direction from the board. I do urge caution, because we do want to make sure that sensitive and confidential information is kept confidential until such time as it is releasable to the public, so.
Yeah, I guess it seems it seems like overkill to me. It is our statutory responsibility. It is our fiduciary duty. We are members of a governance team, and the law tells us confidential information has to stay confidential. And it feels like overkill to not give us that information in the way that's most easily consumed by each of us. That's it. I won't argue anymore. I feel really disadvantaged by this.
It's I think it's just unfortunate there has been a past history. And to guard that confidentiality has to be of the utmost importance. Every board member is either given a hard copy or allowed to read it. You know, and again, I don't see this happening a lot. So I'm not too sure whether we need to do anything at this time. But the next report, if you want to bring it up again, please feel free.
Thank you.
Mrs. Jordan.
I have nothing for the good of the order, just happy Valentine's Day. Thank you.
I have nothing, but happy Valentine's Day, everyone.
Well, I just want to thank the staff, Attorney Dupree Bruno and Ms. Supke, for all of the work that has been done on these policies. I know how long it took me to go through them. I know how long it took me to work through them with the two attorneys. I cannot begin to imagine how difficult it was and how time-consuming it was for staff to go through this, so I want to say thank you. The other comment I will make is, when are we going to, as a board, review 8510 and 9140, which we agreed to come back to because we are not in compliance with our policies and we have to make a decision about how we're going to proceed with those policies. So those are my comments. Thank you.
Thank you. It was a lot to read. There's no doubt about that. Plus, several of us were at the finance forum. So having all that thrown at us for 3 days and then coming back and reading 1,000 policies, it seemed like it was very difficult. But I do appreciate the staff and Neola for all the work they've done and for the board for being prepared. Ms. Patrica.
So in response to Ms. Morgan's question, should we put 8510 and 9140, did you say, on a workshop for discussion before it comes back in front of the board for a reading? Is that what you're asking?
I was asking if we want to do it now
Okay.
or schedule a workshop at a future date.
I think we could do it now. This is a workshop. Can we do that?
Yes. So just to make sure that I understand, based on Mrs. Morgan's comments, it wasn't necessarily the language in the policy, it was more what are we going to do to ensure that things in the policy are occurring. Is that correct, Ms. Morgan?
That,
Yes.
or are we no longer going to, have those guardrails in place?
So I would
yes.
appreciate if we can move forward with that because Neola left and they're going to
Right.
be processing these documents, so.
I thought the policy as written was good. I think we should be following it. I think we should be rotating off these committees. Other comments from, that was one of the big ones.
Yeah, so the 8510 is the one about the wellness committee.
Right.
And then the others were all about the advisory committees and the rules we put in place that we're not honoring. So, I'm comfortable, I personally am comfortable, with the exception of the Fire Chief Association. I don't know why. Why that was done and whether that's statutory, but I'm comfortable with what was suggested we ought to do. Best practice, I guess, is what I would call it.
Right. Mr. Fisher.
I have, through the board chair, a question to Ms. Morgan. Was that also the one we're talking about alternates?
Yes.
Okay. My suggestion, and I'm going to ask this generally of the board, I would perhaps ask to get rid of the alternate language because it seems like we have enough, issues getting enough people just for the regular spots. That's just my suggestion. And go with the way that we've previously been doing it in regards to that. If there's a vacancy, we, do our best to fill that immediately. Thank you.
And may I just say, you're talking about ISOC, so everybody else knows. Yeah.
Yes, Ms. Jordan.
But we put the alternate in there, so if someone would not be able to make it there, they were the filling for that, for ISOC. So they've always been on there. We have alternates on there, because I remember the very first one, it was, Brian Riss was one, there was several that were alternates, and they were there to replace if the other ones dropped off. So they were going there to the meetings to make sure that they understood what was taking place. They were seated there at all the meetings, and then if one fell off, they would then take their place. But I think Brian, and I know there was several of them on there.
But is that the way they've been operating? Because Mr. Rist has not shown up he hasn't shown up in a year.
Again, that's where I was asking if we could put on that one too. ISOC was, because we've had that on several occasions where they never showed up. But there's no stipulation, if you do not show up, that you will be removed on ISOC. So that was never put as part of that policy. So that's probably, and I know we spoke about that and said that we would bring that forward again to look at that, because we do know there was people who've been on there and never showed up the first time. But yet we had nothing in our policy that says, if you do not show up, we will remove you and put someone in there. So that was a caveat that we did not, we need to take care of that as a policy for sure. And that is on the ISOC committee. And I think even Mr. Bruno, if I'm through the chair, I think that question has come up, right? We had asked, but we did not, we had to bring that back for revisiting that policy to fix that.
Yes.
Correct?
Yes. Just so I can follow, Ms. Morgan, do you know the number? I know it's in the 9,000s, and I'm trying to find it.
9140?
Thank you.
Well, 9140 is all the citizens advisory committees. I don't think that one pertain, and I'm so sorry.
There is an ISOC policy, and that's what I'm trying to.
Yeah, that's not on that one. The 9140.
I'm sorry, 9143
Okay.
is ISOC.
Yeah.
Sorry.
9140 is the same as our old 120.
Okay, I found it, thank you. So let me just take a look. So I'm hearing two questions. One is with regards to the alternates, as well as how many meetings can be missed. Is that correct? Okay.
Correct.
As well as the fire chief. I think there was 3.
Can someone refresh my recollection? Was this policy written and in front of the public before the referendum passed? And the reason why I ask is because I would be hesitant to change the policy during the pendency of the first go-around of the half-penny sales tax if this is the policy we told the public would be in place should it pass.
I don't know. I don't remember.
Excellent question.
It is.
I can tell you that the resolution that was passed by the board was not as specific as this policy.
Correct, it was not, but I'm wondering, I think I remember workshopping this before the election, but I don't remember. So can we table this again to get an answer to that question? Because that's going to dictate how I feel about changes. I get that the alternate is not working and it's not likely going to work, but I don't want to, if this is what we promised the community, I don't want to change it.
Ms. Jordan?
I believe that this was done after 2018. So this was done after, because we were part of the board when this came out.
Right, but my question is, did we have a draft of it in front of, were we workshopping this before the election, before that November? And did the public to some extent rely on this language in voting the way they did? I agree with you, we couldn't adopt the policy until after it was passed because the policy would have been unnecessary, but somewhere in my brain I remember talking about this before the election.
So we'd have to do a little research, and I want to
Right.
speak to appropriate staff.
And changes that strengthen it I think will be well accepted by the public. I don't, you're not making it weaker necessarily, except maybe the fire chief being part of it, so maybe we need to leave that one, if that was, or they appoint. Any other comments? I guess we'll table that until we can get a comment.
9143, yes, sir.
Okay, any other questions you had there? I think that was,
So essentially,
Yeah.
8510, which is the wellness, and 9140, which is all the other advisory committees, we're moving forward as they are.
yes, Ms. Jordan.
Sorry. The 9140 is just, it is the policy 1.20 just moved over. So we already have that. I think when I looked at that, it's just us taking what we already had and turning that into the Neola and expanding on that a little bit. So to me, that is, that's good. We just need to keep that with us as a reminder to the committees of what their roles are when they are being appointed to those. So I really did, I'm good with those, me personally.
Ms. Patrica.
So the chair and vice chair only serving 2 one-year consecutive terms, I think that's ideal, but I don't think it's realistic, because I think that a lot of the committees for which I have been the liaison, nobody else wants to do it. And so how do you get water from a stone? If it's the same person that wants to do it year after year after year, you're not going to say, no, our policy doesn't allow that, because somebody else doesn't want to step up as the leader.
Hello?
Yeah. Yes. I'm just thinking out silently.
Thank you. No, the other side of the coin is that there may be people who want to do the job and are intimidated by the people who are running the committee, and I have seen that as well. You tend to have people with strong personalities sort of dictating how these committees operate, and maybe we need to say that, that's the expectation, but it's not a hard and fast rule. But I think that the expectation is that you serve 2 years, you're done. Thank you.
Yeah, I would like to see something like maybe the wording say there's a reorganization of the committee chairs or whatever every 2 years, and see what we can do. But bring it out into the open there. And
Okay, we'll work on the wording for that.
thank you. Yes.
Can I ask one more question? In this, I'm sorry, this is a stupid question, I should know the answer, but does the superintendent appoint a member to advisory committees?
There are some that does note the
I know ISOC for sure. Are there others?
Let me see.
Mr. Superintendent.
I was informed earlier in the year that I only had one committee of which I appoint a member, and that's ISOC. However, there was a situation that was provided to me earlier this year where I appointed someone because I was informed that I was required to, when in fact I could appoint, but it wasn't a requirement for me to appoint.
Okay.
So that particular, I think we should look at that. If I'm not mistaken, it might be the District Advisory Council, but I'm not 100%
That was
sure.
curriculum.
It is the curriculum advisor. It's the
But
curriculum.
I kind of looked for it in here and I couldn't find it. That's why I'm asking a question. And my question to the board is, the ISOC is not a board advisory committee. ISOC is a public advisory committee. Curriculum advisory, all of our other advisory committees are ours. They are board advisory committees. So I'm wondering why we would have the superintendent appoint members when the superintendent has staff liaisons, right? Am I making sense? Like, I would think if we want people advising the board so that we can ask the superintendent to do things, why do we have the superintendent putting members onto those committees? And I didn't see it in policy anywhere where the superintendent is supposed to do it, so that's where the stupid part of my question comes in, like, I should know where it is, but I don't know where it is. So,
Through the chair, it is in the Curriculum Advisory Committee. It says the superintendent may also appoint additional members to this committee to ensure that the interest of exceptional students are represented.
that's it. And I did read that, but it didn't compute with what I was. So again, I would think it would be the superintendent's responsibility to ensure that the staff liaisons to that committee are ensuring that exceptional student education is covered there. So would we like to make that change?
Mr. Superintendent.
Well, Mr. Chair, members of the board, I have a very strong belief about board advisory committees, and the superintendent does not have a role in the appointment of individuals to those advisory committees unless the board warrants and provides that. It would be advantageous for me to step back from that, use my staff, and use those individuals that you appoint to better inform the board so we can find a way and a manner and means forward without superintendent interference of any form. I saw clearly, I think I would like to keep that responsibility because of the nature of that committee.
Right. So consensus on removing the superintendent from the curriculum? Everybody? Okay. Please do that. Okay, any other comments from anyone? Ms. Dupay, do you have
I
any
think,
comments?
Ms. Morgan, you had three. You had, I think, 81.
Yeah, so it was 8510 wellness, 9140
Oh, the wellness.
advisory
Yes, please.
committees, and then the 9143, which was the ISOC. So wellness is the same thing, where we have this protocol for this, it's an ad hoc committee of the board and the whole process, and we don't do that now.
Yes, Ms. Jordan.
And I believe what Ms. Morgan had mentioned earlier is that at one point in time, when Ms. Fisher was here, she was the health guru. So she actually took on pretty much anything health-related is what was on her bucket list, I guess, if you will. But she's the one who had that. So I don't know if that was transferred at the reorg to Mr. Fisher, just saying. But I know that she did have that.
Ms. Patrica.
Two things. Number one, I don't think we've ever had this committee come in front of us during our annual reorg, have we? It's not one of those, so it should be added, because it's my understanding, based on this, that it's required by state law. That's the first thing. The second thing is, and I'm being a pain in the butt with the ad hoc thing, but a permanent committee is not an ad hoc committee. An ad hoc committee is temporary in nature. So ad hoc those words should be taken out of this, and this should become a regular board advisory committee, should it not?
It's required by state law, I would think.
So,
Or by- Yes.
Mr. Chairman, I believe that Mr. Young said that he was going to review this one because the actual committee, we're not sure if it's actually required by state law. And there's another policy that discusses physical education that also has a committee that will be reporting to the board. So if I may, I'm going to pull this one as well as that to make sure that both of those policies coincide with each other. And if we're going to have one health committee, we can have one health committee that addresses all of that, if that's okay with the board.
Yes, I see. Please. Mr. Superintendent, do you have any other comments?
If I may, as a point, just because we won't be back together for a little while before next Tuesday night, I just think there's some things that are timely today. They're not necessarily for the good of the order, but I think they're of value. I was informed last evening, we'll provide you in your update, that the Support Professionals Union in the district have reached tentative agreement regarding salary and other things moving forward. So we'll be providing the details to that to you, which leaves schedule and in your administrators still. And I don't mean to be a downer on Valentine's Day, but my next two ones are difficult. School districts sometimes experience loss and loss unexpectedly. We lost a pretty fabulous employee in Becky Rash, who ran our warehouse operations. I want to just send out love and affection for her and her family in this very, very difficult time, because it was very much an unexpected loss for both her family and our team. Reminded me to remind my cabinet and remind some other people who have been gathered with me recently to keep an eye on your bucket lists. To the public watching, to all of you, write it down. Pick something off that list that you've always wanted to do, that's reasonable, that you can get done. And my suggestion to you is make it a goal moving into this year and into next, because no one's ever going to say, hey, I wish I spent more time on the dais at the very end. And lastly, it is Valentine's Day. And unfortunately, sometimes holidays are sometimes usurped by other events. And I just think it's really appropriate to recognize that this is also, unfortunately, the anniversary of Marjorie Stoneman Douglas. And based on some text messages that were shared earlier in the day with all of you, we all know that we are always one step away from that. And I think it's just important for our community to hear, our staff to hear, that we have a commitment to school safety, and we will do everything humanly possible to prevent it. The incident that occurred today in one of our schools was really the work of being diligent and recognizing some difficult behavior or some odd behavior, and then making sure they ask the question why. And to parents, better to temporarily hold on to a student and search their belongings than to wind up in another situation that affected our neighbors just directly across our peninsula. So in the midst of your Valentine's Day celebration, keep in mind that there are still families and individuals and communities that are recovering. And I appreciate this board's focus on student safety, as you also focus on the curriculum and the other needs for our students and for our employees. So thank you.
All right, seeing no other business, the time is 2:17 p.m. and this meeting is adjourned.
I think we're off.
Chris, I have a